Okay, so previously we discussed Articles 4, 5, and 6. 4 being when criminal liability may attach. So we all know that under Article 4, criminal liability will attach if you commit a felony, although the wrongful act be different from that which you intended, and also by any person performing an act which would be an offense against persons or property, were not for the inherent impossibility of its accomplishment or on account of employment of inadequate or ineffectual means. So your second paragraph tells us of circumstances involving impossible crimes. Now, do not dwell too much on that because again, impossible crimes are the last resort if walay ma-file na case against a certain individual. Now, your Article 5 states that it is the duty of the court to inform the Department of Justice just in case a repeated deviant behavior has been happening in its sala and there is no crime which punishes it, so that its referral to DOJ would also be referred to the legislative department in order for it to be taken into consideration into putting it into a law, or meaning criminalizing it. And lastly, in your Article 6, the stages of your performance in committing a felony, such as your consummated, frustrated, and attempted stages. Now, moving on with Article 7, we will discuss today we will discuss Articles 7 to 10. Now, your 7 to 10 is the last part of your preliminary or your prelims, because the coverage of your prelims would be from Articles 1 to 10. Okay, kung i-include na to ang 11 to 13 or 15, basi bubuang na mo sa pag-memorize. Now, let's begin with Article 7. When are light felonies punishable? So light felonies are punishable only when they have been consummated, with the exception of those committed against persons or property. Meaning, light felonies are only punishable if they have been consummated. Meaning, you, as an individual, committed all the elements necessary for its execution and accomplishment. Also, with the exception that light felonies are punishable if you commit a crime against persons or property. Meaning, an example of your crime against persons is when you commit slight physical injuries, or property when you commit malicious mischief. Malicious mischief is the destruction of a property out of revenge. Very common in Katiil ang malicious mischief. Here, examples are your slight physical injuries, theft, or malicious mischief. Now, the rationale for your Article 7 is that in crimes against persons and property, every stage of the execution is punishable, but only the principals and accomplices are liable for light felonies, while accessories are not. This is so because the penalty for light of felonies is too insignificant if to be imposed upon the accessories. Now, those who are the principals, or those who are the authors of the crime of slight physical injuries, theft, or malicious mischief, are liable only for arresto menor, and that is the pinaka-lowest na penalty to be applied to a person who is convicted thereof. When you say arresto menor, that's only 1 to 30 days, or it may even be a fine of less than 40,000 pesos per Republic Act 10951 and 10951. So, kada siya, ilan pa nimo ang accessories na gamay na kayo sa imo ipataw half day, wala half day. Hindi ka pwede mag half day dito sa pistuhan kay tungod accessory lang ka. So very clear ang balaod ha na only light felonies are only punishable when they are consummated. All right, Article 8. Conspiracy and proposal to commit felony. So, Conspiracy and proposal to commit felony are punishable only in the cases in which the law specially provides a penalty therefore. Meaning, if there is a law that punishes you, if you conspire and you propose to conspire a felony, then you will only be liable for that type of crime. An example is conspiracy to commit sedition, conspiracy to commit treason, and so on and so forth. Mostly sa crimes against the state siya eh. Alright, second paragraph. A conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. Please memorize this because this always comes out of your board exam. When is there conspiracy? So you have to remember that a conspiracy exists when at least two or more persons come to an agreement concerning the commission, meaning you agree to commit, to perform a crime. Now, can a single individual perform conspiracy? Of course not. The law is very clear. It exists between two or more persons. Kung mag-conspire ka with yourself na, that means buang ka. You have a separate entity inside your head. All right, the last paragraph. There is proposal when the person who has decided to commit a felony proposes its execution to some other person or persons. So when you propose, you have decided to commit that and you share it to other individuals. That is proposal to commit a conspiracy. Any questions so far? Naipangutana?
No, sir.
Wala. Right. When is there
Ambot, sir.
conspiracy? Nakipangutana?
O sir, pero in terms ng conspiracy gani, sir, mas bukat ba ang the one who act the commission?
Okay. So that will be answered by the third paragraph, Mr. Sumambot. Once conspiracy is established, the act of one's conspirator is the act of the others. The act of one is the act of all. Meaning, kung unsa ang penalty to be imposed upon the author, it means kamo tanan authors, then you will all receive the same penalty.
Pero sir, katong kaso gani, sir, ni Hermigenes Flora gani, sir.
Kinsa?
Tang Hermigenes Flora gani, sir, katong kauban niya iso niya, sir. Nganong kuan manggod ang pagka-latest manggod ato sa sir, sa trial court kay Hermigenes Flora lang ang naikaso, sir, pagpatay sa usa ka victim, pero ang usa niya nga iso dili. Mas bukang yang
Okay. You see, in conspiracy, Manggod, you have to prove in court that conspiracy exists. Perhaps during the trial of that certain individual, it was found out that he acted on his own and he did not share this proposal to his sibling. Basig ka na ang nahitabo. Kay conspiracy must be alleged and proven during court. So dapat na kay witnesses, dapat sa action sa mga imuhang mga akusado kay na ay common concerted design to prove that they really acted together. So maybe perhaps in that case of in your question, basig it was proven during the court na he acted on his own, or perhaps his sibling was a mere accomplice or an accessory to the crime.
Okay, sir. Thank you.
All right. Sige. So, when is there conspiracy to commit a crime? Conspiracy exists when two or more persons come to an agreement to commit an unlawful act. There must be agreement, consent, nagkauyon mong tanan to commit a felony. Now, conspiracy may be deduced from the manner in which the offense was committed or from the acts of the accused before, during, and after the commission of the crime, indubitably pointing to and indicating a joint purpose, a concert of action and community of interest. For example, mga tao dili. let's say si Sumambot, De Los Santos o si Dugos nag-walk along San Antonio Baybay in Katiil. And then they saw Sean Justin Reynes, of which they really disliked. So nakita nila si Sean Justin. So si De Los Santos, ang iyang gibuhat, gigunita niya ang kamot ni left arm ni Sean Justin. Si Angelo Dugos, gigunita niya ang right arm ni Sean Justin. Para si Mr. Sumambot maka-clear sumbag sa naong ni Mr. Sean Justin. So, from the manner on which they acted, klaro kaayo na they have a common interest to inflict physical injuries to Mr. Sean Justin. Kay gunitan na gud ang kamot. So, klaro kayo na although there is no prior agreement, but there is a concerted action, there is a community of interest between these three individuals to commit a felony or let's say physical injuries on the part of Mr. Sean Justin, then conspiracy exists. Ingana na siya mag-appreciate ang court. So tanawon niya, unsa may example na nakita na witness, ang witness kay si let's say si Miss Pandili, ang girlfriend ni siya ni Sean Justin. Nakita niya na during trial gino niya na De Los Santos, gigunita niya ang left arm ni Sean Justin. Si Angelo Dugos, gigunita niya ang right arm ni Sean Justin. Ano di siya kalihok. Sumambot ang ni sumbag sa iyang naong, sa iyang abdomen. Muna siya na mall si ang akong boyfriend na si Sean Justin. So by that manner, through the testimony of Miss Luella Pandili, then the court will appreciate na there is really community of interest between the three, although there was no prior agreement. Naklaro ang examples for conspiracy. Hello? Hello?
Klaro, sir,
Bumalik
klaro.
pero sa last part, sir.
Ha?
Kung sa last part daw, sir.
Last part?
Baka itong operasi ganun, sir. Itong community of interest.
Community of interest. Meaning from the actions of Mr. Sumambot, Mr. Dugos, and Mr. Kinsatong Isa, De Los Santos, the testimony can be proved that there is concerted action. Meaning when you say concert, sabay-sabay ba? Murag sabayan ang pagkabuhat sa ilang actions, and there is common interest between the three of them to commit such felony. So there is community of interest. Again, so if found out by the Supreme Court, if found out during trial that indeed the Ms. Pandili's testimony is credible, then the penalty of Mr. Sumambot, maski siya ang nisumbag, will also be the same as the penalty to be awarded to Mr. Dugos and De Los Santos. So all of them will be convicted of, let's say, less serious physical injuries or slight physical injuries, depending on how many days Mr. Sean Justin is unable to work. So klaro ang conspiracy, ha? Just ask if you have any questions. Right, sige kani. Question. A, B, C, and D agreed and decided from 7-Eleven, a mini grocery store at midnight tonight. You, a police officer, overheard their agreement and immediately arrested them before they were able to rob 7-Eleven. Is the police officer's action correct? Volunteer. Volunteer?
Sir,
Parang dili, sir.
Sabay mag-volunteer. Julio? What do you think is the correct answer? So, ingani akong mga questions ha during your exam. So, kaya para makutaw na inyong utok.
Police officer.
Ha?
Sir,
Hmm.
pwede try, sir.
Sige, kisabay mo try.
Cabrera, sir.
Cabrera, sige, Cabrera.
For me, sir, no, sir. Mali ang gibuhat niya nga gidakop dahil niya without nga wala pa niya na caught in the act nga nagbuhat og action nga nagrab ang si A, B, C, and D sa 7-Eleven, sir.
Okay, why?
Kuan, sir, kanang pwede man, sir, kanang kanang giplano lang to nila, sir. Mandi ay dili to nila buhaton, murag nag-joke lang, and then para gi seryoso dayon ni sa police officer, sir, nga dakpon dapat unta to, sir, before niya siya gidakop, sir, nag-act unta, kanang nakita unta niya sa action sa kuan mga suspect nga girab niya ang 7-Eleven. Pwede man unta to niya tagaan lang nga og warning ang mga kuan, sir, kanang suspect nga dili na mo dayon sa kuan kanang 7-Eleven.
Okay.
Pero dili niya dakpon, sir.
Sige. Tama yung mong answer na police officer is, the police officer's action is incorrect, meaning mali siya, but your reasoning is wrong. Diba, I already told you, when you reason, you use the provisions of the law, diba?
Okay, sir. Sorry, sir.
Okay lang, sige lang. Just try. Okay, wag yung problema sa kuha mag-try. Ganahan gani ko na mag-try gani. So, Mr. Cabrera, your answer is correct. You use action is incorrect. Why? You go back to the provision here. See? Conspiracy. Use action is incorrect because conspiracy and proposal to commit a felony are punishable only in the cases in which the law specially provides a penalty. Therefore, in conspiracy to commit robbery, there is no crime that punishes it. Hence, hence the action of the police officer is to arrest A, B, C, and D is wrong. Nakuha ni mo, Mr. Cabrera, kung saan pagtubag?
Yes, sir.
Na ha? Sige. So when you are when you are confronted with a question like this, always go back to the provision. Kung sa may magamit na ako na provision na para mo suporta sa kuang answer na yes or no. Actually, in your previous exam sa human rights, naiuban na mali ang ilahang tubag. Mali, let's say yes or no, mali ilahang i-answer na yes or no. But tama ang ilahang citation sa legal basis. Maski tama ilang citation sa legal basis, ginataasan gyapon ako grade because naman may basis sa inyong answer, and I always give credit to individuals who provide a legal basis. Supreme Court magani mag-away-away magani na sila kana silang 14 kung sa bani kung is he liable or criminal liable. Ang uban diha na kay yes, he is liable. Uban diha he is not criminal liable. Sila pagani na mga hawd na nga sila kita pakaha ng mga usap napadiri sa iwit banda. So that's what I'm trying to say. So learn how to argue using legal basis. Mr. Cabrera, I will give you points for answering, okay? Cabrera remark, no?
Yes, sir.
Okay. Right. Now, how do you distinguish conspirators from accomplices? Yung mga accomplices, dugay pa na ito siya ma-discuss, but at least for now, nanamoy gamay na introduction about them. Now, distinguish conspirators from accomplices. Now, they have one thing in common. Both of them know and agree with the criminal design. But there are certain things which you can distinguish between a conspirator from an accomplice. A conspirator knows the criminal intention because they themselves have agreed and decided upon such course of action, meaning the criminal design came from them mismo. They are the source of the criminal intent or the mens rea. Now, accomplice, they only come to know about the criminal design after the principal have reached decision, and only that the accomplice agreed to cooperate in its accomplishment. Meaning, kung conspirator, iguro lang nila gi-relay sa accomplice. So, saman, uyon ka ni or dili. Now, conspirators take direct part, dili siya art ha, direct part in deciding that a crime should be committed. Whereas an accomplice does not take part in the decision whether the crime should be committed. He merely assents to the plan and cooperate its accomplishment. Muna, ginatawag sa mga conspirators, they are the mastermind. Now, conspirators are the authors of the crime, meaning sila yung naghimo, sila yung gikan ang criminal design. Whereas your accomplice, they are merely instruments, the conspirators, in the performance of acts not essential to the perpetration of the offense. Now, any question about conspiracy? Naipangutana about conspiracy and proposal to commit a conspiracy?
None, sir.
None, all right. Let's move on to Article 9. Grave felonies, less grave felonies, and light felonies as amended by Republic Act 10951. So please counter-check your notes. If you are using the codal, the old codal, wala pa rin siya naunsa, wala pa siya ni siya na-incorporate, but with the addition of Republic Act 10951, Article 9 has already been amended, and grave felonies, less grave felonies, and light felonies have already been updated. So now, what are grave felonies? Grave felonies are those to which the law attaches the capital punishment or penalties which in any of their periods are afflictive in accordance with Article 25 of this code. Pasabot, you will commit a grave felony if ang penalty niya is ang capital punishment, reclusion perpetua, reclusion temporal, and prison mayor. Mauna imuha mga grave, mga penalties na makaingon ka, ay, ako na-commit kay grave felony. Now, with less grave felonies are those which the law punishes with penalties which in their maximum period are correctional in accordance with the above mentioned article. When you say correctional, up to 6 years. Now, light felonies are those infractions of law for the commission of which a penalty of arresto menor or a fine not exceeding 40,000 pesos or both is provided. When you say arresto menor, it's only 1 to 30 days. Tapos, ang fine na less than 40,000 pesos is already considered a light felony. Okay, it has already been updated because ang revised penal code, you have to remember, di ba? Effect in the 19 pa. So, i-apply ni mo na today in the modern world na kaya kay akusado kay yung mayroon na kay 200 pesos, 500 pesos, ana kay sila There is a need to update it, and thank God the Legislative Department updated Article 9 through Republic Act 10951. Okay, so question, what are the classifications of felonies according to their gravity? Meaning, how do you classify crimes based sa ilang kabugat sa penalty? So it either be grave, less grave, or light. Sometimes I joke my students na it's grave, it's less grave, and light. So para dali ma-memorize. Now, here are your other summary of classifications of felonies under the revised penal code. Di ba remember na part of your definition of criminal law is that traits of their kind. Now, hindi siya ang ginapasabot niya, it treats of their kind because it provides what classifications felonies may be categorized. So under Article 3, you all know that felonies may be committed either by act or omission, or they could be intentional or culpable felonies. Based on the previous lecture, you know now that there are certain stages of when a felony is committed, such as your attempted stage, your frustrated stage, and your consummated stage. And lastly, now, Article 9, you now know that the gravity of the offense that has been committed may be classified according to grave, less grave, or light felonies. Your grave, less grave, light felonies. So very clear ha kung how felonies are classified based under the RPC. Nagyan na ninyo ni siya for sure kay we've discussed them thoroughly previously. Okay, what are afflictive penalties? So under Article 25 of the Revised Penal Code, they are the following. Like I said, it's reclusion perpetua, reclusion temporal, and prison mayor. What are the correction penalties? So under Article 25 is prison correctional and arresto mayor. What are light felonies? They are infractions or violations of the RPC where the prescribed penalty is imprisonment of arresto minor or a fine not exceeding 40,000 pesos or both. So daghan yung pag-ingon ng mga weird na mga terminologies and sama sila. So this is your table of penalties. Diba, afflictive penalties include reclusion perpetua, reclusion temporal, and prison mayor. So kung sa man ang duration ani nila. So in its entirety, when you are given with the penalty of prison mayor, then you will receive a penalty of 6 years and 1 day to 12 years. Prison mayor, morning mga Republic Act 9262 or VAUSI, let's say for example, you commit a crime of violence against women and children because you caused substantial abuse and psychological abuse to a woman to whom you are dating or having a sexual relationship, or to your wife. So if found out to be guilty, you will be held liable for the crime of Republic Act 9262 and will be meted out with a penalty of prison mayor, which its penalty, its entire duration would be from 6 years and 1 day to 12 years. The reclusion temporal, in which the penalty, its entirety would be from 12 years and 1 day to 20 years. So, ano inyong mga afflictive penalties? Ano inyong mga grave felonies? Reclusion perpetua, reclusion temporal, and prison mayor. Reclusion perpetua is life imprisonment. So, question, asa diri sir imuhang ginaingon na correctional penalties? So your correctional penalties would involve prison correctional and arresto mayor. So sa maning arresto mayor, ang duration ani? Duration niya would be 1 month and 1 day to 6 months. This is very common for less serious physical injuries. Arresto mayor. Example, sumbag ninyo siya tapos out of commission siya for more than 9 days kana arresto mayor na siya. Then prison correctional from 6 months and 1 day to 6 years ang iyang entire duration. Usually ang mga crimes under prison correctional are acts of lasciviousness, imuhang PD 1602, acts of lasciviousness kana manghipo gani kag babae, ipuon nimo ang boobs sa babae o kana iyang pipi kana. So that's you will be meted out with the penalty of 6 months and 1 day to 6 years. PD 1602 kanang inyong mga hantak, karai cruise, kanang illegal gambling. 6 months and 1 day to 6 years na siya. And lastly, you have here your light felonies, arresto menor. So you will only be held liable from 1 to 30 days. Example, kay katong slight physical injury or malicious mischief. I have one client na nadaog me na na-convict na po sila due to malicious mischief, but gihatag lang is 11 days of imprisonment. Ano, kay light felony naman, ila lang man giguba ang property sa akong client. So, mo to 11 days lang because it's a light felony. That is your arresto menor in its entirety, 1 to 30 days. But I tell you, a day inside the detention cell is like forever, my God. To the point na naalang sila dito for 2 days, mahimo lagi silang anghel, ilahang kanang muna lagi silang itay kayo after 2 days, kanang buot na kayo, mag-sorry na sa imuha. Kana naka-worse dito sa detention facility. And lastly, you have your, naipangutana? Question? Question?
No, sir.
Wala.
None, sir.
Okay, sige. Alright. Let's move on to the last article. Article 10, offenses not subject to the provisions of this code. Offenses which are or in the future may be punishable under special laws not subject to the provisions of this code. This code shall be supplementary to such laws unless the latter should specially provide the contrary. Ang pasabot lang ani is that if there are offenses which are committed, but if you commit an offense sa special laws, dili na mo gamiton as reference ang revised penal code because the special laws will be the source of that crime. So ang special law na mismo ang mag-provide sa iyang penalty, sa iyang penalty. Like for example, under Republic Act 9262 or the Violence Against Women and Children, if you commit a crime there, then di na nimo kinahanglan mag-refer to the revised penal code because RA 9262 is complete in itself. So all you have to do is just look for the provisions under which a crime was specifically committed. Let's say, for example, na may physical abuse, na may economic abuse, na may psychological abuse, na may emotional abuse. Pili na ka dito, asa man siya na-hit. And then you will find also there kung unsa po ang iyang corresponding penalty. So, mo lang ang pasabot aning Article 10. Any questions so far? Naipangutana?
Wala, sir.
Wala. All right. So that ends your coverage for the preliminary